Right now, we turn our attention to the Newsmaker Hotline, where Attorney General Jonathan Skrmetti, it seems like, AG, every time I talk with you, you're fresh off another victory. Congratulations, sir.
Thank you. It's been a good streak. We got a great team here working hard.
Well, it's good to talk with you. I hope everybody's well.
Yeah, we're doing well. We're staying very busy.
Well, I know you are. This recent victory that we refer to, the United States Supreme Court denied a request to review a lower court that had already agreed with you in upholding the Tennessee adult entertainment case. It was Friends of George's versus Mulroy. Let's kind of walk back and look at it from 50,000 feet, if you don't mind, Attorney General. Tell us just give us the 25-word or so viewpoint of what the law does in the state of Tennessee that was passed in 2023.
Yeah, so the law says you can't have sexually explicit performances in front of kids. That's the gist of the law. That's all there is to it. And there's been a lot of litigation trying to argue things that the law doesn't say. But the law is very clear. It is the Adult Entertainment Act, and it protects kids from adult-oriented performances.
And so embedded in this law is not some sort of poison pill that will eliminate the ability for grown people to go and watch, topless dancing or cabaret or that sort of thing. None of that is in the law.
Right. It's just about kids.
And where did the lawsuit come from? Tell us about that.
So Friends of George's is a theater company in Memphis that puts on different plays, including drag plays. But, Mrs. Doubtfire has a character in drag through most of the movie. Nobody's saying that's illegal. The law isn't focused on saying if you've got somebody dressed as a woman, that's illegal. That's been happening since Shakespeare's time and before that. What it says is once it becomes sexually explicit, once there's any sort of touching or simulated or real activity or other, what I think most of us would easily understand to be explicit activity, that you can't do that in front of kids.
You could probably cite chapter and verse the case that comes to my mind, but it was the one where the definition of obscenity. I don't know how to define it, but I know what it is when I see it.
Yeah.
And it was a fairly famous comment from a U.S. Supreme Court justice. So it feels as if there are certain people that are intentionally picking nits when it comes to the language in an effort to try to get this overturned, when the obvious intent is to prevent risque or explicit performances in front of children. For most Tennesseans, I would imagine, and for you, Attorney General Skrmetti, I would imagine that this is a pretty cut and dry piece of legislation.
Yeah, there's a lot of rhetoric around it, but, at the end of the day, it's a very simple standard, very straightforward standard that's been in the law all over the place for a long time. And, the court of Appeals and the Supreme Court didn't disturb the judgment, said, what you're worried about is not illegal.
And typically, in your experience, when a Supreme Court, as they have done, they could choose to take up the case and they can choose to just say, no, it's all good. And what is the messaging behind that? Does it depend case to case? What do you take away from the Supreme Court saying, listen, we're not going to get involved in this?
So, this was a pretty technical request for the court to come in. The legal argument here was that the Tennessee Supreme Court's narrowing of particular language should not have been relied on by the federal court when they were interpreting this statute. The broader context here is, this was an attempt to have a big free speech case saying the government can't limit expression. And, we're Tennessee. We love expression. This is a state full of musicians and artists and authors, people who value the First Amendment, plenty of political speakers here too. But there are lines. The Constitution doesn't protect explicit performances for kids. So, I think this is an example of people overreading what the law prevents. And I think the court's reaction here was just, this is not the case that we want to take up to get into these really narrow, complicated, technical legal issues. we're not going to undo what the Court of Appeals decided.
Well, it was a big victory for the state of Tennessee. It was one that was fairly obvious to most of us that read the legislation, that watched the law be passed, that have watched you defend it through the court system. I mean, it is a time constraint. It is, it takes away money from other needed issues, but at the same time, I mean, this is part of the system that we live under, right? That people are well within the rights to file lawsuits, as frivolous as they may be, just as long as we get the proper and constitutional decisions on these matters. That's what's key at the end of the day, I would imagine.
Amen. I mean, we have these processes, and it can be frustrating and it can be expensive, but we have these processes as another way to guarantee our freedoms. And so, my office is always happy to stand up and make the legal arguments on behalf of the state. And sometimes you just got to work through it. But, I'm very heartened that the courts ultimately came out looking at what the statute actually did rather than reading somebody's account of how horrible it was without looking at the words the legislature passed.
Mm-hmm. Well, and this comes on the heels, I would note, of another victory of sorts for you, Attorney General Skrmetti, and the state of Tennessee, when the Trump administration, thankfully, is now in power, and they backed off the Biden-era Department of Justice. I guess the Department of Justice was coming after the volunteer state for our ban of transgender surgeries and puberty blockers. You were at loggerheads with the DOJ under the Biden administration. And I think it was, a couple of weeks ago that the Trump administration completely dropped any and all efforts to challenge you in court. Is that not the case?
That's correct. And that's the case that went up to the Supreme Court. But one thing the Trump administration said was, even though we don't disagree with Tennessee anymore, we hope the court continues to take this case, because the ACLU also argued in the case. They also filed their briefing. And we really need clarity on these gender identity issues. This is the first constitutional case to look at gender identity issues. And there are so many lawsuits and so many lower courts that are confused or that need the guidance. So hopefully the Supreme Court still comes through with a very clarifying opinion to stop some of this litigation.
AG Jonathan Skrmetti with us for a minute or two longer. There was another victory that I noted. The Tennessee Supreme Court this past week ruled that state law mandating only the Tennessee Attorney General can handle post-conviction death row cases is, in fact, constitutional. Give us some of the backstory on this, AG.
Yeah, so, death penalty cases are serious business. Usually there are a lot of appeals. Usually there are a lot of post-conviction motions. The way Tennessee law used to work, most of the stuff after the death sentence came down came to my office. But some of the post-conviction in state court went to the DA's office. And there was an incident where one of the DAs had agreed with the defense that one of the death row inmates was not intellectually suited for execution. And so there was no adversarial process there. And this new law makes it so that my office will step in and defend the capital sentence once the DA obtains it. And that way, you can't have someone come in who changes their mind. In our system, the sentence comes down, and then it's the state's job to defend the integrity of the sentence unless and until the law and the facts don't allow us to do that. You can't have somebody come in who just doesn't like the death penalty. And, you've got these families that have been waiting for decades for justice who are just left in the dirt based on a policy disagreement. Our Constitution lets the governor do that if he wants to do that, but it doesn't let a DA come in and just decide that he didn't like the way a case came out before. And
for those curious, this was Shelby County District Attorney Steve Mulroy, who was challenging your authority in this case, which obviously the Tennessee Supreme Court said that you have the authority and that Mulroy does not. Obviously, the General Assembly in session in the minute or so that we have left, is there anything on your radar screen, Attorney General, and maybe there's not. I don't know the answer, obviously, to this, is why I asked the question. But anything on your radar within the General Assembly, anything that your office is particularly interested in terms of the law while the Assembly is in session?
I mean, there's a lot. We have regular meetings internally, and we have a lot of communication with our various clients in the General Assembly. Without going into specifics, they have been very focused on immigration issues, and it seems like there's going to be some significant change with respect to how the states participate in immigration. We're seeing this in states across the country. So I suspect we're going to be involved in various pieces of immigration-related litigation going forward. I don't think that's all we're going to get out of this session, but I suspect that's going to be a big part of it.
It's kind of part of what your office, and I'm not asking for any particular details, but your answer it occurred to me, part of what your office kind of must do is look at some of the laws that are passed and anticipate the types of organizations or entities that would sue. Whether they can win or not, they will throw it into court. And I guess you kind of have to anticipate that sort of thing, don't you?
Oh, we do. There's a lot of people out there who like to litigate. And as you said before, that's part of the process. This is America. You're allowed to do that. But we like to have a plan as much as we can going forward. And we got a great, very active General Assembly that makes sure that we never have a chance to get bored over here.
Well, that's the deal, is that we got to keep you busy over there in the Attorney General's office. Keep you guys churning and burning. Well, listen, in all seriousness, thank you for everything that you do. Congratulations on the victory in the Supreme Court. I mean, obviously they didn't hear the case, but that in and of itself, considering the appellate court decided on your favor, is a victory. And we appreciate you stopping by to give us the details, Attorney General.
It's always a pleasure. Have a great day.